think confiscation means regulatory agents kicking down your door and seizing your specialized hardware, you're missing the more dangerous threat that's already happened. This is about de facto confiscation. And here's why it's more insidious than anything you've been told. The government doesn't need to send agents to your house. They don't need warrants. They don't need to physically take anything. They just change a bureaucratic rule. And overnight, your legally purchased hardware accessory becomes a felony to possess unless you register it, destroy it, surrender it, or face federal consequences. This happened with stabilizing components. It's happening right now with unserialized frames. And if you don't understand how this tactic works, you cannot protect yourself from the next one. Quick question before we dive in. Are you subscribed yet? Because what I'm about to reveal is how the administration is using bureaucratic reclassification to accomplish what they cannot achieve through the legislature. We're talking about millions of owners being threatened with serious charges for possessing items they bought legally. Hit that subscribe button right now because 90% of owners don't understand this threat until it's aimed directly at them. Don't be part of that. 90%. Subscribe. Turn on notifications. Let's break this down. All right, let's start with what de facto confiscation actually means. Traditional confiscation is easy to understand. The government passes a law, agents show up at your door, they demand you hand over your hardware, they physically seize your property. That's direct confiscation. De facto confiscation is different. De facto means in effect or in practice without being officially stated. In other words, the government achieves the same result as confiscation without actually coming to take your property. Here's how it works. Step 1. You legally purchase a hardware accessory, let's say a stabilizing component. You buy it from a licensed dealer. You use it for years. It's completely legal. Step 2. A federal agency issues a new rule redefining that accessory. They say it's no longer an accessory. Now it's a heavily regulated item under the National Registry Act. Step 3. The agency gives you an ultimatum. You have a limited window to either register the item and pay a fee, permanently destroy the item, surrender it, or become a federal offender. Step 4. Most owners don't comply. Either they don't know about the rule, they don't agree with it, they can't afford the registration fee, or they refuse on principle. Step 5. Those owners are now in possession of an unregistered regulated item. That's a serious federal offense, 10 years in custody, a $250,000 fine, loss of ownership rights forever. The government didn't physically take your property, but they made it a crime for you to keep it. That's de facto confiscation. You're being forced to give up your property under threat of prosecution. And this isn't theoretical. This happened with stabilizing components in 2023. Let me walk you through exactly what occurred. In January 2023, the federal agency published a final rule in the public record. The rule was titled Factoring Criteria for Items with Attached Stabilizing Components. The rule created a new framework for determining whether a compact unit with a stabilizing component should be classified as a regulated short-barreled unit. Background for context. A stabilizing component is a device designed to attach to the rear of a compact hardware unit. It wraps around your forearm to stabilize the equipment. These components were invented in 2012. The agency initially approved them. For over a decade, millions of citizens legally purchased units with these components. They were not heavily regulated. They did not require registration. They were considered standard compact units, not regulated short units. But the new rule changed that. The agency said that if a unit with a component met certain criteria, it was now a regulated short-barreled unit. The criteria included weight, length, optics, marketing, and a bunch of other subjective factors. If your unit met those criteria, congratulations. You now possessed an unregistered regulated item. That's a serious offense. The agency gave owners 120 days to comply. The deadline was May 31st, 2023. You had 4 options. Option 1, register your unit as a regulated short-barreled unit. File the necessary federal paperwork. Submit fingerprints. Submit photos. Pay a $200 fee. Wait for approval. During the 120-day amnesty period, the agency waived the fee. But after May 31st, you'd have to pay. Option 2, permanently remove and dispose of the component. Turn your unit back into a standard compact unit. Keep the hardware. Throw away the component. Option 3, turn your unit into a full-length standard unit. Attach a longer barrel and a fixed stock. Now it's a legal standard unit. Not a regulated item. Option 4, surrender the entire hardware to the agency. They'll destroy it. You get nothing. Most owners chose option 5, which wasn't listed, do nothing, and hope the rule gets struck down in court. The agency estimated 10 to 40 million units were affected. Legislative research agreed with that range. Only about 250,000 people registered. That's less than 1% compliance. That means millions of citizens were potentially committing federal offenses after May 31st, 2023. This is de facto confiscation. The government didn't come door to door. They just reclassified your legal property as illegal and threatened you if you didn't comply. If you're finding this helpful so far, imagine what you'll learn in my next video where I break down the 5 agency rules that are currently being challenged in federal court. Subscribe right now so you don't miss it. Now, here's the part most people don't know. The component rule was challenged in court. Multiple lawsuits were filed. Advocacy organizations like the Hardware Policy Coalition and others sued the agency. They argued the agency exceeded its statutory authority. The governing acts define exactly what a standard unit is. A standard unit is designed to be fired from the shoulder. The agency cannot change that definition through a bureaucratic rule. Only the legislature can change the law. The lawsuits also argued the rule was arbitrary and vague. The criteria were so subjective that owners couldn't know if their property was legal or not. That violates due process. The case that mattered most was a citizen versus the administration. Later, it became a high-profile case after the change in legal leadership. Advocacy groups represented the plaintiffs. The case was filed in a prominent circuit court. In May 2023, the court issued a preliminary injunction. The court said the plaintiffs were likely to succeed on the merits. The rule was likely unlawful. The injunction blocked enforcement against the members of those advocacy groups. In August 2023, the court expanded the injunction. The court said the agency's rule was probably unconstitutional. In June 2024, a federal district court granted summary judgment for the plaintiffs. The court vacated the rule entirely. The rule was struck down. In another case, a federal judge issued a nationwide injunction in late 2023. That injunction halted enforcement across the country. By mid-2024, the component rule was effectively dead. Courts across the country had ruled the agency exceeded its authority. In July 2025, the new administration's legal department dropped its appeal. The government agreed to dismiss the case. That was it. The rule is officially vacated. It is no longer enforceable. These components are legal again at the federal level. If you registered your unit during the amnesty, those records are still on file. But the requirement to register no longer exists. The agency has not provided guidance on removing those records, but the underlying rule is gone. This is a massive win for owners. It proves that challenging agency overreach in court can work. But here's the critical point. For over 80 years, millions of people lived under the threat of federal prosecution. Many people destroyed their components. Many people surrendered their property. Many people paid money to register items they shouldn't have had to. That's the damage of de facto confiscation. Even when the rule is struck down, owners have already suffered. They've already complied. They've already lost money. They've already lost property. And they've lived in fear. Hey, quick reminder. 73% of people watching this video right now are not subscribed. That means you're going to miss the next major rule change or court victory. Don't be in that 73%. Click subscribe right now. All right. Now let's talk about unserialized units. This is the other major example of de facto confiscation, and this one is still in effect. In April 2022, the administration issued a rule redefining what counts as a regulated frame. The rule targeted 80% finished parts and home-built kits. An 80% part is a partially finished frame. It's a block of material that has been machined to about 80% completion. The buyer has to finish the remaining 20%, drill holes, mill out the internal cavity, complete the machining. Once it's finished, it becomes a functional regulated frame. Before the 2022 rule, these parts were not considered hardware. They didn't require serial numbers. They didn't require background checks. You could buy them online. You could build a unit at home for personal use. That was legal. The agency's new rule changed that. The rule said that certain unfinished frames are hardware if they can be readily converted. The rule also said that kits are hardware if they include everything needed for assembly. If these items are now hardware, they must have serial numbers. They must be sold by licensed dealers. Buyers must pass background checks. Manufacturers must comply with all federal regulations. The rule created the same ultimatum as the component rule. If you owned an unserialized part before the rule, you had options. Serialize it, destroy it, surrender it, or become a federal offender. Unlike the component rule, this one was challenged but upheld by the High Court. The case is leadership versus manufacturers. It went through several name changes as the legal leadership changed. The case was filed by manufacturers, specialists, and owners. They argued the agency exceeded its statutory authority. The law defines hardware as a weapon designed to expel a projectile. The plaintiffs said 80% parts do not meet that definition. They're not weapons. They can't expel anything. They require significant work to become functional. The case went to a district court in Texas. The district court agreed with the plaintiffs and vacated the rule. The case went to a higher circuit court. That court also sided with the plaintiffs. The court said the agency's definitions were broader than what the legislature wrote. But the government appealed to the High Court. And on March 26, 2025, the High Court reversed the lower courts. The vote was Yadai to Ike. A senior justice wrote the majority opinion. 6 other justices joined the majority. 2 justices dissented. 1 justice wrote a separate dissent. The majority opinion focused on a specific buy, build, shoot kit. This kit included everything needed to build a popular style unit, a partially finished frame, all internal parts, tools, and instructions. The court said this kit is a weapon because its intended function is obvious. The kit's name says it all. The court acknowledged that the kit requires about 20 to 30 minutes of work, but that doesn't change the fact that it's designed to be converted. And the law says hardware includes items that may readily be converted. The court also said partially finished frames can be regulated if they're close to completion. A part that just needs a few tabs removed and holes drilled can fairly be called a frame. Now here's the critical part of the decision. The court did not say all 80% parts are hardware. The court specifically said some products may be so far from finished that they cannot be regulated. The court left that question open for future cases. What the court said is that the agency's rule is not facially invalid, meaning the rule can apply to some specific products. It's not unconstitutional on its face, but individual products might still fall outside the rule's scope. So the rule stands for now. This is the opposite outcome of the component rule. The component rule was struck down. The unserialized unit rule was upheld. That means if you own an unserialized part or kit, you need to understand what the law requires. If your product can be readily converted, it's now regulated as a standard unit. It needs a serial number. It can only be sold by a licensed dealer after a background check. If you already own one, the agency has not announced an amnesty period. Technically, possessing a part that qualifies under the rule is a violation of federal law. This is where de facto confiscation is still active. Owners who bought these parts legally years ago are now in a legal gray zone. The High Court said some of these products are hardware. But which ones? The court didn't say. That ambiguity is exactly what makes de facto confiscation so dangerous. Quick legal note. This is educational information only. It is not legal advice. The agency's rule is complex and fact-specific. If you own these items, consult with a specialized attorney in your jurisdiction. Do not rely on this video to make legal decisions. Get professional legal counsel. Now let me explain why this matters so much. The previous rule affected an estimated 10 to 40 million items. This rule affects millions of parts and unfinished frames. These numbers are staggering. We're not talking about a few thousand people. We're talking about millions of citizens who legally purchased products and are now told they might be illegal. And here's the part that should be a warning. The agency can do this again. They can issue a new rule tomorrow, reclassifying any accessory or component as a regulated item. They could target triggers, they could target barrels, they could target magazines, they could target anything. And when they do, you'll face the same ultimatum. Register, destroy, surrender, or become an offender. This is not traditional confiscation, but it achieves the same goal. It removes property from civilian hands without passing a new law. It relies on fear, compliance, and the threat of prosecution. Most owners will comply rather than risk federal charges. That's the strategy of de facto confiscation. It's politically safer than direct action. It doesn't create viral videos of agents seizing property. It doesn't spark immediate backlash. It just quietly reclassifies your property and dares you to fight back in court. Fighting back costs money. It takes years. Most people can't afford it, so they comply. All right, let's talk about any you need to do to protect yourself. First, stay informed. Subscribe to advocacy organizations that track rule changes. Groups like the Hardware Policy Coalition and others monitor federal agencies. When a new rule is proposed, they'll alert their members. You need to know about threats before they become final rules. Second, participate in the comment process. When the agency proposes a rule, there's a public comment period, usually 30 to 90 days. Anyone can submit a comment. Comments matter. They create a legal record. They force the agency to respond. They provide evidence for future lawsuits. Don't skip this step. Third, support litigation. When advocacy groups sue the agency, they need funding. Lawsuits are expensive. The previous major case took over eeky years and cost hundreds of thousands of dollars. Your support funds those battles. Fourth, know your local laws. Even if a federal rule is struck down, your state might have its own restrictions. Certain regions have their own bans and hardware laws. Federal victories don't always override state laws. You need to know both. Fifth, document everything. If you own items that might be affected, keep receipts, keep purchase records, keep proof that you acquired them legally. If the agency ever comes after you, you'll need to prove you weren't violating the law at the time. And sixth, don't panic, sell, or destroy your property. If a new rule is announced, wait. See if it gets challenged in court. See if it gets stayed by an injunction. The previous rule was stayed within months. Many people destroyed their property before the injunctions were issued. They didn't have to. They panicked. Don't make that mistake. Let me give you one more critical point. De facto confiscation only works if you comply. The agency estimated millions of units existed. Only a tiny fraction were registered. The rule failed because owners refused to comply. They challenged it in court instead, and they won. The agency cannot enforce rules against millions of citizens. They don't have the resources. They don't have the manpower. They rely on voluntary compliance and fear. If citizens refuse to comply and instead challenge unconstitutional rules, the system works. That's what happened with the component rule. The rule was struck down. De facto confiscation was defeated. But you have to fight back. You cannot just comply and hope it gets better. Compliance is surrender. Litigation is resistance. And resistance works. All right, let's bring this home. De facto confiscation is the modern threat to ownership rights. It's not agents at your door. It's bureaucrats in the Capitol issuing rules that reclassify your property as illegal. The component rule tried this. It affected millions of units. Owners fought back. The rule was struck down. It's officially vacated. These components are legal again. The unserialized unit rule tried this. It affects millions of kits and frames. Owners fought back. But the High Court upheld the rule yeti de iki. The rule is still in effect. These are the two major examples, but they won't be the last. The agency can issue new rules anytime. And when they do, you'll face the same ultimatum. Register, destroy, surrender, or face charges. This is de facto confiscation. And it's more dangerous because it's harder to see and harder to fight. Your best defense is to stay informed, support litigation, and refuse to comply with unconstitutional rules. Courts can strike down bad rules, but only if owners challenge them. If this video helped you understand this threat, do Ikey things. First, subscribe. I track every major rule change in every court case. I'll keep you informed, so you're never caught off guard. Second, share this video. Every owner needs to understand de facto confiscation. We can't fight what we don't understand. Legal disclaimer. This video is for educational and informational purposes only. It does not constitute legal advice. Agency rules are complex and change frequently. Local laws vary. Federal laws change. Always verify current law and consult a licensed attorney in your jurisdiction for specific legal questions. This video reflects information available as of early 2026 and may not include the most recent developments. Stay informed, stay ready, and I'll see you in the next one.